Take this off and put it down here. I actually have a shirt on today, a pink shirt.
Is that a sound effect?
Effect? What's a sound? What's a sound effect?
Good afternoon and welcome to AM News Network presents Summary Judgment, our weekly show aired from the American News Media Center in Harwinton, Connecticut. I'm attorney Rachel Baird, and I'm joined by my co-host, legal investigator Edward Peruta, president of American News and Information Services.
And good friend of Joe Cool from Chicago.
Ed, we are running a little late today, and I apologize because
8 minutes.
I ran to Staples. I ordered online, ran to Staples, and the price they tried to charge me for these 600 documents that have to do with the Ninth Circuit appeal we have was $19 more than the online quoted price. So
give them the real reason you're late.
So we're running
I
late.
had to put a pink shirt on because I didn't want anybody to think that I was wearing the same shirt this week that I was wearing last week.
Now, I had a good experience ordering online with Panera Bread. You order online, and you have a little on your face still from the sandwich. You order online, and you go, and you just pick it up. And I'm thinking, well,
Wow.
anyway, yeah.
And you paid for it online too?
Paid for it online, just
Okay.
went and picked it up.
If Dan could come out and hand me my coffee over there, I'd be very happy.
And the problem...
This is going to be a reading show.
Well, when Dan comes, if he could
Right
also
here.
take the Cuban sandwich, because the dog
is going to
circling
eat
it
it. The
right
dog
now.
they're circling the wagons
Yeah.
around the sandwich.
Yeah,
No,
they're-
don't worry, you're not on.
You know what interns are for stuff like coffee?
Thank you
boy.
very much.
Oh boy, Master Control has an attitude today. Have to watch it.
Extra
He's had an attitude all week.
Oh, now the dogs are his friends. Look at that, they're following him. So again, our letter brief is due to the Ninth Circuit Court of Appeals on Monday.
Yep,
Has to be electronically filed,
yep.
which means that when it's midnight in Connecticut,
It's 9 p.m.
there.
So
Usually you have till midnight to electronically file, but we actually have till 3 a.m. our time Tuesday morning to electronically file because they're 3 hours
Right.
behind.
Joe?
So it's like we get an extra 3 hours.
Okay.
Okay. I know
All right.
you hate it when I do
So
that.
let me turn the volume down on my phone. Okay. And I have to tell you that I was very pleased to have been granted a what do they call it? An exception in Americans with Disability Act accommodation in the federal courthouse with Judge Underhill.
Right, down in
I
Bridgeport.
was allowed to leave my phone on, and that means that the ringer is on. And then I went into a Connecticut court in Rockville, Connecticut, and I was permitted to leave my phone on and the ringer on because I am on a heart transplant list. Now, to get this out of the way so everybody knows, they did some tests, some blood tests on me this week. And Dr. Jason Gluck called me on the phone yesterday
Yes.
and told me that my heart is not doing well
Right.
and that he recommended that I come into the hospital so that they can put a pump to assist my heart into my thigh,
Right.
and that I would be in the hospital for possibly 2 weeks with a pump in my leg, building up my heart and whatever. And then he dropped the bombshell on me. He said, hopefully by the end of the 2-week stay in the hospital, you will have a new heart.
They moved you from a level 4 up to a level 2.
I moved from a level 4 candidate for a transplant to a level 2.
Mm-hmm.
And I kind of said to him, I said, Doc, that fast? And he said, yes. And I said, all based on a blood test? He said, yes.
Mm-hmm.
And basically what it is they don't want the deterioration of my heart to deteriorate my kidneys or any other organs.
Yep.
And I got to tell you, I have been treated with kid gloves and respect and concern and compassion at Hartford Hospital in Hartford, Connecticut, in the advanced heart failure and transplant unit. I've been treated wonderfully on the floors there by the nursing staff and the doctors. And so I kind of hoped that what would happen is I'd get a phone call. I would drive to the hospital. They'd knock me out and rip my heart out and give me a new one. And I'd wake up with a new heart. And I wouldn't have to think about it. Well,
Yeah, you're going to have nothing.
yesterday he said to me, I could bring you in today. And
Nothing but time.
I said, I got to do a show tomorrow. Can you at least give me a little bit of leeway here? And some breathing room? And then it was, you got to call your wife, your son, your daughter, your family members, whatever. Got to call Rachel and say, Rachel, I got something I got to tell you. And she kind of guessed it ahead of time.
Well, let me tell you what happened. You went in for the test.
Blood test.
A blood test about
10
noon.
o'clock.
No, it was after court, so it was about 11:30 or noon.
Okay.
And so then we went to lunch, and you got a phone call
Right after lunch.
that, we didn't take enough blood, so you need to
You
come
need
back.
to come in and redo the test.
So we didn't really think twice about it.
But I had to go to another doctor at 2,
Mm-hmm.
so I got in early to that doctor, and he saw me. And, Dr. Wayne Polikas in Wethersfield, Connecticut has been fantastic with me. And basically what he said to me was this. He said, Ed, because he'd been my doctor for like 30 years. He said, Ed, from this day forward, you do not have to make an appointment to come in here. If you call up and you say you need to see me, I'm going to instruct everybody in the office to bring you right in. So he gave the instruction. I got in my car. I went to Hartford, and I took the second blood test.
And you went up by yourself to take the second blood test.
Because Rachel was working on her laptop on a legal matter in the car.
And I'm sitting in the car, and all of a sudden it popped in my mind. What if they called him back and just used that not enough blood as an excuse, but they're rechecking something that looks a little suspicious?
Well, a carpenter has the motto, measure twice, cut once.
Right.
And I think that you could be correct. I'm not going to second guess why they brought me in for the second
No,
round.
it's perfectly fine.
But
I get it.
it was the type of blood test where they draw. I have a PICC line that goes from my arm up through my shoulder down into my heart, where I've been receiving 24/7 medication to try and help my heart function.
Because you know what, Ed? When it comes to something important like that, of course you want to check and double check and not just go by one test reading, which brings me to another case that we were discussing this morning. And that's the case of Dr. Henry Lee's testimony in a 1989 murder trial.
In Connecticut.
In Connecticut, 2 teenagers were accused of killing
Elderly male.
well, he was 64. I don't know how elderly
That's
that
elderly.
is now. And it doesn't seem elderly to me now, but killing a
older
64-year-old man, supposedly a burglary gone bad. They interviewed the kids. The kids admitted it, right? Or there was some kind of confession, or they lied about something because they had in fact stolen a car that evening, and they were afraid of being arrested for stealing a car, so they lie and end up getting arrested for murder. And the state Supreme Court just came down with a decision this week reversing those convictions. Now, one of the
coming
kids is
down
still in
kind
jail.
of hard on the infamous Dr. Henry Lee.
I mean, think about it. One of those kids is still in jail from 1989.
Well, there's some issues going on, but
no, we got to finish the story, right?
Let me wrap up. Mine.
Okay.
So I am going to tell everybody right now. I may not be here next Saturday. I hope that Rachel.
You may not be at the show next Saturday. Let's clarify.
I hope that Rachel can find the wherewithal to continue this while I'm in the hospital. Well, something big may happen. Got to talk about it. Mm-hmm. So now we can go back to Dr. Henry Lee if you want, but I think that it's going to take me a while to read into the record some of the issues that J.C. Playford presented to the courts.
What do you mean? Read on the show today?
Oh, yeah.
Okay. Well, yeah, we'll just tie it up. So basically, a lot of the evidence in that case was circumstantial back in 1989.
If you go to Google, and I'm sure you can Google, Connecticut Supreme Court decision, Dr. Henry Lee. Mm-hmm. and you'll be able to read it. And Dr. Lee evidently had a news conference where he's adamant that he didn't do anything wrong. You know, resting on his laurels.
Here's the basic information from the situation. He testified that there was blood on a towel, which confirmed the narrative of the state that there was an attempt to clean up what had happened, I guess. And it turns out that there was not blood on the towel. It was not blood, the substance.
20 years later, they test the towel.
In 2008, at the habeas, a scientist from the state lab came at the habeas trial where, the two people were claiming that they were wrongfully convicted and testified that there was no blood on the towel. So Dr. Henry Lee, about 5 days ago, came out and said, well, there was a field test done on the towel. But there are no notes or no reports. And so my question is, at the trial, you have somebody testifying that there was a forensic test done. Okay, where's the paperwork that shows the results of the forensics test? Did Henry Lee ask that? Did the prosecutor ask that?
Did the defense attorney
Did the defense attorney ask that? If somebody is coming out saying something is blood, you want to see the test showing that, right?
And that's what you do best.
But that's just obvious.
All right. So,
Okay.
Done with Dr. Lee. Now,
Okay.
Last week, and I would ask everybody on the other side of the camera to go back to last week's show and listen to it, where we discussed the recent Supreme Court decision in Nevis v. Bartlett out of the state of Alaska in the Ninth Circuit Court of Appeals, where the Supreme Court ruled on an issue regarding probable cause, constitutional violations, and in that decision, they came out with Part D, fourth Part D, where they carve out an exception that if certain elements are present, if certain things are there, then the whole decision doesn't apply. Now, if the decision in Nevis v. Bartlett does not apply, then you have to sit there and say, well, are there any decisions that do apply? So now you take Playford and you say he has all of the elements necessary to fall under the exemption in Nevis v. Bartlett.
Right.
So Nevis v. Bartlett, in my opinion, and I'm just a layperson who read it, does not apply to the current case of American News and J.C. Playford versus Gore.
Well, first of all, in J.C. Playford's case, was there even probable cause for the May 25th, 2012 arrest? That's where we're going to start with. And then we're going to say, even if there was probable cause, the circumstances are such that there's an exception where he can still claim First Amendment retaliation.
That's correct.
Got it. And then there are three other arrests in J.C. Playford's case where he either pleaded or was convicted. And so you can't argue in those cases that there wasn't probable cause. But what we could argue is, even if there was probable cause, those cases meet the exception, correct?
Right. Now, I'm going to read Part D of Nevis v. Bartlett.
Excellent.
Although probable cause should generally defeat a retaliatory arrest claim, now that means that if you have probable cause and the person that got arrested says this was a retaliatory arrest, probable cause should defeat any attack on whether the arrest was legal or not. A narrow qualification is warranted. So I'm going to start. Although probable cause should generally defeat a retaliatory arrest claim, a narrow qualification is warranted for circumstances where officers have probable cause to make arrests, but typically exercise their discretion not to do so. Now, what they used as an example was jaywalking. Everybody's jaywalking through an intersection. But you know something? I know that guy or that lady right there, and they've given us, whatever, heartache and complaints. So when that person walks across the intersection, we give them a ticket for jaywalking. Yes, the officer had probable cause. The person was jaywalking. But the officer let everybody else similarly situated just walk through the intersection and jaywalk and did nothing.
You made me think of, that's the whole reason why officers, when they're giving out tickets and making motor vehicle stops, they have to keep track of the race and demographics of the people that they stop, because while you can say, yes, this person was speeding, this person was doing this or that, the whole reason for these racial profiling laws is because it came to the attention of people who then pushed for legislation that certain groups were being stopped more often than others. That's the whole principle behind that.
100 cars go down the highway at 110 miles an hour, and the speed limit's 55. All of those cars get to go by the officer with radar, but there's one person who's busted this officer's stones for 5 years. And he has a very distinctive red pickup truck with floodlights on the top. And down the road, he sees that vehicle coming up doing 80 miles an hour. He pulls that vehicle over and issues a citation for speeding because he has history with the operator and the owner of the vehicle, and he knew that vehicle is the one I'm going to stop. If you can prove that there was animus, if you can prove that the arrest was based on retaliatory intent, rather than just like everybody else, I just randomly pulled you over because I had probable cause to do it. That's the way I look at it. Now, it goes on to say, in such cases, an unyielding requirement to show the absence of probable cause could pose a risk that some police officers may exploit the arrest power as a means of suppressing speech. In other words, you know something? Every time J.C. Playford comes up to a scene, we're going to, knowing that he's going to resist and argue with us, we're going to tell him, you can't come here, you have to go back, you have to go around the corner, you have to go up the road a half a mile, because that's what they told me and Kim Dvorak, was we had to go down the road a half a mile.
Hey, how about this situation, Ed? A bar owner or a restaurant owner where alcohol is served somehow gets on the bad side of the police.
Yep.
And the police start staking out his restaurant at about midnight, 2 a.m., whatever time they close. And people who come out, they watch, and they watch him drive a little bit, and they stop him for DWI. And it makes this restaurant owner lose business because people feel like they can't go there and drink because they're under scrutiny by the police when they leave.
Law enforcement has a lot of ways.
I don't know if anybody would be successful challenging that, though, because people look at DWI in such a way that it's like, well, they deserve it, which, of course, it is against the law. And, yes, you shouldn't drink. But people at other restaurants deserve it, too, if you're going to take that theory. So why are we focused just on this restaurant owner?
Gotcha.
Yeah.
Okay. But that is D. Now, this is a document.
So there were parts A, B, C, and D, and basically what the majority of the court, 5 members, said in sections A, B, and C, they made the argument that probable cause defeats a claim for First Amendment retaliatory animus in an arrest. But then in Part D, they said, okay, we're going to make this one exception, and here's what the exception is, and that's what you just read.
Right. Now, and I have to beg the...
What Ed's looking at right now is the appendix to the Ninth Circuit
This is the
case.
appendix?
Yes,
Okay.
it's the record on appeal. everything that was filed in the lower court that's of importance for the Ninth Circuit to consider.
This could take a while to read, but I think that it's important that we have a video record of exactly what we said to the court. And I would go as far as to say everything that's in here is provable.
But we didn't have a chance.
We didn't have a chance, but everything that we've said is provable. Now keep in mind that retaliatory, the animus, where they don't like J.C. Playford and what he does, animus and retaliatory conduct, you've made complaints about us, so now we're going to arrest you. And the fact that if someone else similarly situated is allowed to do it and not interfered with, and the only reason they're doing it is because it's J.C. Playford and they have the animus and the retaliatory intent in their head to confront him, to stop him, and to keep him from doing what he does. Okay. Now this says nature of the case, and I'm going to skip into this. The nature of the case. This is a civil rights action challenging the policies, customs, and practices of the San Diego County Sheriff's Department that obstruct rights guaranteed under the 1st, 4th, and 14th Amendments of the United States Constitution. Now,
I mean, we had a lot of claims in this case. The seizure of JC's camera, reviewing the contents of the card on the camera.
right. You can put those in when I'm done
Okay.
reading.
That's okay. I got it. I got it. The holes are uneven. I don't understand why.
And I'll start with item C. Okay. By excluding Playford, a duly authorized representative of American News, from a news conference called by San Diego County District Attorney Bonnie DeMonis on or about January 4th, 2012, and attended by media with government-issued media credentials. J.C. Playford went to attend and record, and that possibly ask questions, at a news conference held by the district attorney for San Diego County. He gets off the elevator, or he go into the room, and there's a sign, and he has a picture of it.
Mm-hmm.
Only people with San Diego Police Department media credentials can attend. JC didn't have San Diego media credentials. He had American News media credentials. He was not allowed to attend. 3. The San Diego defendants, or Sheriff's Department defendants, animus towards Playford and the First Amendment is express and apparent in an agreement condoned by San Diego County Sheriffs, which permits. Now, this is the memorandum of understanding between law enforcement and San Diego County. Here's what it permits, the policy. The San Diego Police Department has exclusive authority in San Diego County to issue, quote, recognized press credentials, unquote. So American News can't issue any. TV stations, newspapers can't issue any. Only the Sheriff's Department.
It says sole, S-O-L-E.
Exclusive.
Exclusive. Okay.
Okay?
Wow.
Law enforcement officers within the jurisdiction of San Diego County and its municipalities, explicit direction and excessive discretion to prevent lawful access to and recording of public safety activities in public areas. In other words,
So they can exclude people from having
anybody they
lawful-
want.
When they say exclusive, do you think they mean that within government agencies, for example, San Diego PD's doing it and San Diego County doesn't do it? Or do you think they mean exclusive, period, government and non-government?
You wrote the word.
Well, I did, but
You did, but here's what it is.
I took it right off their rules at the website.
Here's what it is. In San Diego County, the Sheriff's Department has exclusive authority and the right to issue pistol permits. Local police departments do not issue pistol permits. Only the Sheriff's Department. Although they could if they want, but by agreement, only the sheriff's department issues pistol permits. And in turn, every police department in San Diego County, I guess, could issue media credentials, but by a memorandum of understanding between law enforcement and government agencies, only the San Diego Sheriff's Police Department has the exclusive right to issue. Others do not. And the California Highway Patrol got out of the business of issuing media credentials. Okay. Law enforcement officers within the jurisdiction of San Diego County and its municipalities to engage in official duties without adequate training or direction in the First Amendment prohibition against the infringement of the press. In other words, we believe and we allege that when a police officer has to be trained and certified, in the training process, they are not properly trained in how to address claims of media status. And why is it that the California Highway Patrol says, you got a business card with your name on it that says media? We'll accept that. But the Sheriff's Department and other municipalities in San Diego County do not.
This is the complaint you're reading from.
Law enforcement officers within the jurisdiction of San Diego County and its municipalities to act under the color of law with retaliatory animus against individuals exercising rights guaranteed under the First and 14th Amendment without concern for sanction from their superiors. J.C. Playford has made internal affairs complaints. He's provided video of the violation. Exonerated. Go about your business. Oh, let's promote you from deputy to corporal, corporal to sergeant, sergeant to lieutenant, lieutenant to captain. No problem. J.C. Playford, we're not going to deal with him. E. Law enforcement officers within the jurisdiction of San Diego County and its municipalities to target Playford for retaliatory arrest and prosecution by publishing and distributing one or more photographs and a physical description of Playford to identify him as an individual prohibited from lawful access to and recording of public safety activity within the entirety of San Diego County as a duly authorized representative of American News. Now, there is a photograph of a Polaroid photograph of J.C. Playford that was evidently posted on a wall in a law enforcement agency in San Diego County, and we have credible information, factual credible information, that somehow a photograph of J.C. Playford was supplied to the U.S. government's Marine Corps Air Station at Miramar, to the military police unit, and it was posted on a wall in their facility. F. Law enforcement officers within the jurisdiction of San Diego County and its municipalities to censor and exert prior restraint upon Playford and other individuals from lawful access to and recording of public safety activity within the entirety of San Diego County by attaching the threat of retaliatory arrest and prosecution to such lawful activity. Mr. Playford, if you don't leave right now, if you don't go around the corner and be behind the building where you can't see what's going on, I'm going to place you under arrest. Well, guess what? J.C. Playford used to do like I did. Stick your hands out and say, let's go, let's find a judge. But for Playford's refusal to allow his First Amendment activities to be chilled prior to February 23rd, 2010, and his refusal to chill his First Amendment activities as a duly authorized representative of American News, thereafter led to 4 separate arrests and prosecutions, seizure of his personally owned camera during one of the events, seizure of an American News camera from Playford in 2 of the events, a warrantless search and seizure of American News work product contained in the camera in at least one of the events, and indicative of a government hostility hostile to rights guaranteed under the First Amendment. Exclusion from a public news conference on public property called by the San Diego County District Attorney Bonnie DeMonis. 5. A jury of 12, after hearing evidence on Playford's May 25th, 2012 arrest and considering a copy of California Penal Code 409.5, which was included in the evidence and submitted to the jury at the commencement of deliberations, acquitted Playford of any criminal violation in a unanimous verdict of not guilty, announced on September 11th, 2013. Now,
A year and a half after the arrest.
year and a half after the arrest.
And we amended the complaint because we had filed the complaint prior to that verdict, and then we amended
Right.
to add it.
At the time, Playford was a member of the, and it says
And
Playford is.
we added a false arrest claim, too. Now, false arrest, you definitely need to show no probable cause
Right.
for false arrest.
Playford is a member of the National Press Photographers Association since March 25th, 2012, an agent of American News in the business of news and information gathering and recording since February 23rd, 2010, and a freelance journalist and videographer. American News is a news and information company incorporated in the state of Connecticut and owned by Edward A. Peruta that operates throughout the United States and which gathers and provides raw, breaking news video, photographs, and news tips to various mainstream media outlets. Edward A. Peruta is a resident of Rock Hill, Connecticut, and San Diego, California. Peruta is a member of the National Press Photographers Association, NPPA, since March 25, 2012, and the founder and sole stockholder of American News. NPPA is a nonprofit organization dedicated to the advancement of photojournalism and its creation, editing, and distribution. Its almost 7,000 members include television and still photographers, editors, students, and representatives of businesses that serve the photojournalism industry. Since its founding in 1946, the NPPA has vigorously promoted freedom of the press in all of its forms, especially as that freedom relates to photojournalism. I'm not going to read that.
And just as a side note, American News celebrated its 30-year anniversary
On June
recently
12th.
on June 12th, 2019. Thank you.
Okay, hold on. Now, this goes to, well, I guess I got to read some of this. Defendant San Diego County is a municipal entity organized under the Constitution and laws of the state of California. Defendant Jan Caldwell, in her capacity as the San Diego County Sheriff's Department of Public Affairs Director, supervises the Public Affairs and Media Relations Office for the stated purpose of interacting daily with television, radio, and print media to ensure the most up-to-date and reliable information is released to the public. The Public Affairs Media Relations Office expressly grants credentialed media superior access the most up-to-date and reliable information. See, and we reference a brochure, and provides for after-hours access to credentialed media on a deadline. Caldwell is sued in her individual capacity and in her official capacity as San Diego County Sheriff's Department Public Affairs Director. Defendants Jesse Allensworth, James Brenneman, and Michael Proctor are sued in their individual capacities and are currently, or were at the relevant times, alleged in the complaint, each employed as a deputy sheriff by the San Diego County Sheriff's Department, acting under the authority of the San Diego County Sheriffs to Playford's detriment. Now, these are the people who were involved in the May 25th, 2012 arrest of J.C. Playford on State Road 67 in San Diego County. At all times relevant to this complaint, the defendants acted under the color of state law. And now JC's going to get a resume here.
Well, I mean, the point we made in here was that JC used to have a very positive and constructive relationship with the San Diego County Sheriff's Department, correct?
Right.
And then when basically 2 incidents happened, that all changed. And
Okay.
that's this part of the complaint, right?
Now, this is going to be interesting. Playford commenced his career as a freelance journalist and videographer in 2007, recording wildfires near Ramona, California. He often is the first journalist to arrive at and record law enforcement, fire protection, and medical emergency responses to public safety incidents. Playford has provided and sold his work to CNN, TMZ, True TV, MSNBC, ABC, NBC, CBS, well, it's not a complaint, but he sued everybody. Playford and American News YouTube channel, News Now San Diego, now this, whatever date was on this, has more than 5,900 subscribers. He now has 33,000 subscribers. And in excess of 2 million hits. Well, he's well beyond that. Soon after he began his work as a journalist in 2007, Playford applied for and was granted SDPD, San Diego Police Department, press credentials. So they gave them to him. Playford enjoyed a positive rapport with law enforcement developed over a period of years. JC had no problems. In 2003, Len Yurkis, a 22-year-old veteran of the San Diego County Sheriff's Department, provided a written account of his first meeting with Playford at a restaurant when Playford approached him to donate to a fundraiser for a deputy's family killed in a motor vehicle accident. Yurkis observed that Playford had a pleasant demeanor, was a professional in his trade as a painter, a non-drinker, and a hard worker. And now I'm going to go down. It's going through people that said nice things about JC.
I know. He had all
Okay?
these letters he provided me where people wrote recommendations and positive things about JC.
On July 25th, 2008, Playford captured an audio-video recording of San Diego County Sheriff's Department deputies beating Alan Baker outside of a drinking establishment, Molly Malone's, in Ramona. Playford posted his recording of the Molly Malone's incident on the internet and was called by the defense as a key witness in the criminal prosecution of Alan Baker. San Diego County Sheriff's Department deputies harassed Playford and intimidated him not to testify for the defense in the criminal prosecution of Alan Baker. Playford, a big whatever. The city warned Playford on August 24th, 2009, that his media credentials were in danger of being revoked,
But they didn't say why.
as information had been received from the San Diego County Sheriff's Department that Playford had, quote, filed complaints and court actions against deputies in which there had been apparent questionable recollections and accounting of the facts. That needs to be highlighted and circled.
Ah! No. These
No?
are my... Yeah.
Okay.
What page is it on? I'll make a note.
Page 9.
ER 371. That's the record.
Item number 32.
Okay.
That's when they warned him that he had made complaints. This August 24th, 2009 warning letter from the city, leveraging Playford's media credentials to control the content of his news gathering, commenced a pattern and practice of retaliatory measures employed by the San Diego defendants to manage Playford's access to information of public interest, especially pertaining to law enforcement activities. 34. The August 24th, 2009 warning letter recites SDPD policy DP1-31 regarding media credentials, which states, quote, a media identification card may be revoked if the holder refuses to obey an order given by a peace officer at an incident under control by the police department or fire department and thereby jeopardizes public safety and order or interferes with an investigation. The letter provides no explanation of a connection between the conduct attributed to Playford that resulted in the August 24th, 2009 warning.
I just had a thought, Ed. I'm looking at the First Amendment, and the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That doesn't apply. That's the first clause. That doesn't apply in this case.
Okay.
Second clause, Congress shall make no law abridging the freedom of speech or of the press. So abridging the freedom of speech or abridging the freedom of the press. There's a principle in law that says no language is superfluous. There's always a reason why something appears in a statute or in a constitutional provision.
Right.
So you can't just say, well, abridging the freedom of speech or of the press, those are the same things. Well, if they were the same things, then they wouldn't have said each of them, right? So what is the difference between abridging the freedom of speech and abridging the freedom of the press? And which one does our case deal with?
Both.
Now, Nieves versus Bartlett just dealt with freedom of speech.
Right.
It didn't deal with freedom of the press. And that was one of Justice Ginsburg's problems with Nieves versus Bartlett. She said, oh my God, what the majority is doing here today, based on some drunken comment made by an onlooker at a festival, could affect the media. It could affect transparency of government.
That's right.
But maybe it doesn't have to. Maybe Bartlett can be completely separate because it only addresses freedom of speech from J.C. Playford's case, which addresses abridging the freedom of the press.
Right.
And the press doesn't have to be saying anything to abridge it.
It
only has to be there. We got a call?
We have plaintiff Playford on the line.
Oh, okay. Plaintiff Playford?
So let him stay on the line for a while. Hold
Okay.
on. Okay? Because there's something I want to read in here.
Oh, okay. Well, let's see what he has
Okay.
to say, Ed. We'll give a little break to the complaint.
Mr. Playford,
Mr. Peruta,
how are you?
pretty good. How are you, sir?
Good.
That's what I like to hear.
He calls me regularly now to ask how I'm doing. Go ahead.
What are we talking about today?
What are we talking about? We're talking about you and your case. That's what we're talking about. We're talking about the
Oh, yeah,
First
my
Amendment.
phone got behind pulling shit up this morning.
Yeah.
Did you go to Verizon?
Huh?
Did you go to Verizon?
I got that on my phone.
You got YouTube Studio on your phone.
YouTube editor.
Okay, good. All right, sit here and listen to this, and then you can comment.
Okay.
It's a good connection today.
Hold on a minute.
Say that again?
It's a good connection today.
Oh, cool. That's I'd like to hear that too.
I'm looking
How
for.
are you doing, Rachel?
I'm doing good. I'm listening to Ed.
I'm looking for one specific area. May have been on page. Here it is.
Good.
You can put
Got
those
it.
away. We're talking about what happened on May 12th, 2012, State Road 67,
May 25th, sir.
May 25th. Okay.
Mm-hmm.
Hey,
At the criminal trial held in September of 2013, on Playford's May 25, 2012 arrest, California Highway Patrol officer Joseph Nielsen testified that San Diego County Sheriff's Department Deputy Allensworth told him prior to any contact that CHP officer Nielsen had with Playford that Playford's credentials were not valid and that Playford was not legitimately part of the media. That is on page 12.
Okay. Well, no, go by these numbers because there's a lot of pages 12 because it's all
ER?
different documents. Yeah, that's the
ER
record.
374.
That's the page number of the record.
Yep.
Got it.
Item number 48 and 49. Now listen to this. According to CHP officer Nielsen, these comments about Playford's media credentials caused CHP officer Nielsen to believe that Playford's media credentials may have not been correct.
Valid, he said.
May have not been correct.
Okay.
We're going to go with what's here, JC. We're not going to try and remember because there is a transcript. I believe there may be some video involved when he started asking you for other types of identification. Nielsen did. Okay?
Correct.
But you had, and he had, and yeah, I'll just tell you, they seized his American News Media card, and it has never been returned. Correct, JC?
Correct.
All right.
Correct.
All right. And then it goes on. American News is an information company registered with the Connecticut Secretary of State, dated June 12, 1988, operated throughout the United
Don't
States,
read fast.
which gathers and provides raw breaking news, video, photographs, and news tips. Okay, so you can take this over there. There is a portion in here, I'm sure, about Karen Brainerd. Okay.
I'll look for it.
Oh, yeah, where Proctor said she snuck in. I love it.
Yeah.
Now, when did he say that? Did he say that at the trial?
He said that at the trial.
Right.
Despite the evidence sitting in front of him saying, hello, we let her in, I let her in, he let her in.
Well, here's the whole thing. You see, Proctor has to lie or misrepresent and say that because he's captured on radio announcing the fact that J.C. Playford's coming.
Right.
And he did not announce the fact that Karen Brainerd was coming. And so the only way he can get out of the evidence of we were only trying to stop Playford is we have to say, well, we didn't know Karen Brainerd was going down there. Yet Karen Brainerd says she drove right past them.
Matter of fact, I believe there's actual paperwork where it was written down where they said she's in.
She's on the scene.
They let her in.
She's on scene. I think in the computer-aided dispatch, the CAD reports, the radio reports from San Diego County, they announced the fact that Karen Brainerd's there, and then it's Playford's coming down, and everything. So, what it comes down to is this, JC. Sometime on Monday, Rachel has to file a letter, no more than 10 pages of information, to the Ninth Circuit Court of Appeals as to why Nevis v. Bartlett does not apply to you and Lozman does.
That's correct. All you got to do is look at them and you can see that.
The greatest part of your case is this. We have video of Karen Brainerd, the quote-unquote other similarly situated individual, just walking down the northbound side of the road Nobody's interfering with her. Nobody tried to stop her. Nobody put a tape up. Nobody did shit. And it was only when Playford was coming that Brenneman started to put up the tape. There's no plug.
Correct.
No, don't worry about it.
You're
I'm good. So,
That's not the first time they have done that to me.
no, JC. Look, I don't know how many people that are currently watching News Now Houston, News Now San Diego, Summary Judgment Talk Show, or Joe Cool's channel in Chicago, or North Georgia, or North California, or News Now this, or News Now that, or whatever. It doesn't take a rocket scientist to see what law enforcement is attempting to do. Now, let me just tell you something. Last night, I stayed at Rachel's house. And I was watching a program called Live PD. Live Police.
Oh,
And here were deputies in California, Texas, Georgia, Rhode Island, law enforcement in Rhode Island. The cameramen are right up the cop's ass when they're going after somebody. When they got him on the ground. Go ahead.
Correct. Same thing with the TV show Cops.
Right.
If you show cops in a good light, cops will let you film. If you don't show cops in a good light, you cannot film.
Exactly. And usually you'll find that it is an elected head of law enforcement who permits the media in, and appointed heads of law enforcement tend to not permit it.
Right.
I mean, I watched a little bit of that, and the one scene they had the gentleman on a stretcher putting him into an ambulance. Now I've
And
actually
you don't hear anybody screaming HIPAA.
you
No.
don't. But I've heard police officers say that here in Connecticut. You can't film that, this and that. But they're right up on him, filming the guy being put in the ambulance.
Right.
Now let me give you an example.
Yeah.
Those camera people were wearing what looked like protective vests, bulletproof vests. And they had embroidered or stenciled on the back of their vest, media, MEDIA. And they were carrying a shoulder-mounted camera. Because I was trying to pay more attention to where the cameras were allowed to be than what was going on in the video, because I've seen that 1,000 times. I wanted to see where the cameras are permitted.
That's what I always look at.
Now, I will tell you this. The camera people were able to zoom into the cars. They focus on the handcuffs. They focus on the leg shackles. They focus on the what's the gun they hit you with?
Taser.
Stinger, the taser arrows stuck in the guy's back.
Right.
Hip at my ass. Nobody was saying hip out there. And they didn't
Right.
say to a person,
Nobody's saying you're too close. Get out of here.
they were in the state of Missouri, and they just walked into somebody's house with cameras. And my question is this: do they have media credentials? Are
They
they
even have permission to be in that
are
house.
they employed by government when they go into that house?
Well, here's what I think, because this issue did arise on cops. I think there was a lawsuit.
Oh yeah.
I think what they do is they record, but then, or what should happen, if people don't agree, then they can't release that video.
And I want to say, not just cops. I think it may have originated out of Rescue 911. In other words, they would go to a scene, and the cameras from the production company would follow the cops or the firemen right into the person's house and start videotaping. And the lawsuits... Go ahead.
Then they got because it's inside the house and it's a live production show, they actually got to get consent forms to use their images. All these people you see on live TV will sign a consent form.
Okay, that makes sense.
Okay. What I'm trying to say is this, is
So
that
makes it no longer media on their vest.
if you're in my house and I have sex toys on the kitchen counter and you record that and broadcast it to somebody, you've invaded my privacy.
Right.
If I come out of the bedroom wearing in my underwear, you've invaded my privacy. Now,
Right.
I believe that when there's a fire, the fire department owns the ground they work on while they're working. In other words,
Right.
the owner comes up and says, "Get out of my house." He says, "Fuck you. Your house is on fire. Go stand out there." And they'll place the owner of the house under arrest and they'll put the fire out.
Right.
Because they have to worry about the fire spreading. Fire has absolute control when they're working a fire, and they may have absolute control when they're working other type of public safety incidents. And government gave our fire service that privilege, that right, so that we could protect the public from it going further. There was a fire in Chicago, there was a fire in San Francisco, that's it. Done. We're here till the fire's out, and then we leave.
I mean, that's one question that came up with the Boston bombing, right? They were looking for the two people that they had identified as being responsible, and they were going door to door in that one neighborhood and asking everybody, "Can we come in?" What would have happened if somebody said no?
No.
I remember we had that conversation.
We did at the time. You and I had that conversation. What if it's a drug den, and the owner says, "You ain't coming in here"?
Well, I think that's clear. I think you need a warrant for that. Yeah, that's
I think
a little
you do.
different.
But we heard of no refusals
Right.
in Boston. I'm sure there may have been some refusals. In other words, standing at the door saying, "I assure you, they're not in my house. You are not coming in."
Because let's face it, if they go in for that reason and they see something in plain view, they can use it.
So, JC, when did you start watching? Long after we started
This morning,
the show
I
today?
haven't been able to watch it. My phone was, because of my location, I was having a hard time pulling it up, so I thought I'd call and find out what was going on.
Well, here's what you missed because I haven't told you yet. You ready?
Okay.
I'm going into the hospital Monday morning. They're going to put a device in to help my heart work. And I've been told by the doctor that I could be in the hospital for 2 weeks. And during that 2-week period, I'm probably going to get the heart I'm looking for.
Sweet.
Yep, they're moving me from a level 4 on the recipient list to a level 2 to prioritize my getting a heart.
It just goes to show you anything's possible. I mean, never in my wildest dreams did I think Ed Peruta would ever have a heart. I thought he would always be like the Scarecrow.
No, the Tin Man? Who didn't have a
Oh,
heart?
yeah, the Tin Man. Who didn't have the heart?
I don't know. I can't remember. What did the Tin Man? What did the Scarecrow want? A brain?
Courage, right?
No, the lion wanted courage.
Oh, yeah.
The Scarecrow wanted a brain,
The brain,
and
yeah.
the Tin Man wanted a heart.
Yes.
So from now on, you can call me Tin Man.
Tin Man. Hey, so in this complaint that you were reading earlier, Ed, I want to read this while JC's on the line. Jan Caldwell went to a Society of Professional Journalists meeting.
She did.
And I believe that was in March of 2012, right after JC's arrest, about
Right.
6 or 7 days after his arrest. And the North County Times reporter named Brandon Lowry quoted her and put it in the newspaper. And when I deposed Jan Caldwell, I went through these quotes and I confirmed with her that she had said these things. And she did. She confirmed that she said these things.
Fuzzy slippers?
Because it's one thing for a reporter to say you said it, but that doesn't necessarily mean you said it.
It's hearsay until she admits it.
You have to ask somebody, did they actually say it? So let me just read some of these quotes. Do you remember them, JC?
Yeah, these are on camera, by the way. They were all filmed.
Exactly. So one of them was, well, Playford is known amongst the deputies, especially in North County, because he's an issue. If I'm on scene, there's an excellent chance that Playford will be there. Every contact I've had with him has been negative. So this is what the PIO for the San Diego County Sheriff's Department is saying about a member of the media. Now, does that sound like an official policy or custom or perspective on JC?
All right, well, let's do this. Read her statement one more time, and I want to respond immediately when you're done.
Something else I was going to say, too. Oh, you know what they're trying to claim? They're trying to claim, well, she made this statement on March 31st, 2012, after J.C. Playford's arrest. So therefore, that doesn't show there was animus before the arrest. This is after the arrest.
Whoa. J.C. got arrested May 25th, 2012.
Right?
When did she make that statement?
Supposedly March 31st, 2012, 6 days
60
later.
days prior.
In January 2010.
Oh my God, you're right. You're right.
The
You're
animus was there. Now, so read again.
2010.
Just
Yes.
read again what Jan Caldwell is alleged or admits to saying. Just read it, and then I'm going to respond.
It says, well, Playford is known amongst the deputies, especially in North County, because he's an issue. If I'm on scene, there's an excellent chance that Playford will be there. Every contact I've had with him has been negative. That's Jan Caldwell.
Okay, now.
Well, maybe she should turn it into a positive because she is a negative bitch. She wants control.
Well, let's let Ed comment on it.
Here's what Jan Caldwell has said. And I say that in my... J.C. Playford is known to deputies in the North County, San Diego, North County. She says it, I agree. And that every time Jan Caldwell is on scene, J.C. is usually there. Well, that's because the PIO comes out to major news events to handle the media coverage. She says it, I agree with it, because I was at a shooting at a casino where JC and I got hassled by her. Okay?
She starts it all.
Now,
She starts everything.
but here is the bottom line. She says he's known. She says he shows up at major events. And she says that he's always causing trouble. And I don't know what she said after that. I know some of the things, but here's what I say. So if a PIO knows that Playford is a problem to deputies in her department, and that she, when she shows up, has always had problems with Playford, what proactive steps did she take to address J.C. Playford's activities at scenes? How did she instruct her deputies or her supervising deputies to deal with a media representative like J.C. Playford?
Oh, I did. She disseminated a poster.
We'll ask a question.
Well, what I'm saying is, you'll never be able to quote unquote prove it, but here's what she did. She started telling people, arrest him. When they said, well, just arrest him. And then people started to formulate plans. Well, here's how we get rid of Playford. And this happened to Eddie Baird. We're going to arrest him. We're going to wear him down in court. Say he cops a deal and pleads to something and he gets 1 year's probation with certain terms of conditions that he can't do this, do that, or do this. And then if he tries to do it, we arrest him again. And we get him for violation of probation. And it just keeps piling up on him.
And we diminished their credibility, so they're not accepted as the real media. They're called fake, like happened to JC at the courthouse a couple weeks ago. So they attack you to diminish your credibility.
You know, in Nevin
Caldwell. In like, what was it? It was like November 2009. At a fire scene in Poway, where it was roped off, when she came to speak to the media, where the media was set up to speak, saw me standing there, and she grabbed everybody and she said, "You all come underneath this yellow tape where the real media can be. Playford ain't coming over here." 2010.
You know,
There was a home invasion where 6 people got kidnapped out in Valley Center. People came in to rob their marijuana thing, and they were having a party. They all got held up at gunpoint, and when I went out there, 2 other stringers took forever to get out there. They had an old-time sergeant sitting there, and he goes, "If one of you guys is J.C. Playford, you can't even be here." Now, here I am on the side of the road, and he's going, "You can't even be here, according to Jan Caldwell. You are not media, and you are to not get into our press conferences." Out in the middle of nowhere.
the great part of it, JC, the great part of this is we don't have to prove all of the incidents that occurred. We only have to prove the ones that we alleged, or we have to point out those parts of your complaint that fits within Part D, the exception carved out in Nevis v. Bartlett. We have to prove to the court, and I believe that we have the evidence to do that beyond a reasonable doubt, that Nevis v. Bartlett does not apply to J.C. Playford because we meet all of the criteria, every piece of criteria, to fall within the exception that was agreed to by 7 out of 9, or 8 out of 9.
8 out of 9.
8 out of 9 justices agreed with the decision in part or in whole. And all of them agreed with Part D, except Justice Thomas.
Right.
So that's 8 out of 9, right?
Agree there should be an exception.
That's 8 out of 9. All agree. This is what you need to have Nevis v. Bartlett not apply.
Well, I mean, let's make it clear. Justice Sotomayor doesn't think that, she doesn't really agree with the exception because she thinks the rule should be you don't need to show.
You don't need an exception,
right? Because you don't need probable cause.
But the way they worded their dissents or their concurrence,
right?
They all but one agree that the exception is in place. Now what needs to happen is the federal courts and the appellate courts and the Supreme Court need to have cases come forward that expands that exception and narrows what Nevis v. Bartlett is saying. To, if you're a drunk in a crowd of drunks, hassling or just shooting your mouth off for no other purpose than to just do it, yeah, you got freedom of speech, but you're probably going to end up getting pinched, and they're probably going to have probable cause to do it. That's not the case of J.C. Playford or American News v. Gore.
Let me just clarify that quote that we were just discussing was from a newspaper article, the North County Times, in March 31st, 2012, which you're right, did precede the May 25th, 2012 arrest. But the Society of Professional Journalists meeting, where we have some other quotes from Jan Caldwell, that occurred on February 19th, 2013. And that's where
10 months after the arrest of J.C.
And that's where they make the argument, well, that came after, so that's no proof of what people were thinking before.
We have in the complaint an allegation of March of 2012, 2 months prior to J.C. Playford's arrest on May 25th.
And the comments that she made in February 2013 were directed more to non-government credentialed media rather than just pointed at J.C. Playford. Here's some things she said, because they're just outrageous to listen to. Quote, first of all, and my first point I want to make, now remember, this is the public information officer for the San Diego County Sheriff's Department.
For any government agency, this is a public information officer paid big bucks to say the right thing, not the wrong thing.
Overpaid.
It's okay, JC, you know, whatever.
First of all, and my first point I want to make is be nice to me. I mean, seriously, be nice to me, because I'm a mirror and I will reflect how you treat me. If you are rude, if you are obnoxious, if you are demanding, if you call me a liar, I will probably not talk to you anymore.
Stop right there. Jan Caldwell,
Yeah.
a public information officer, does not have a monopoly on being a mirror. In other words, J.C. Playford is a media mirror. You fuck with him, and he fucks right back with you. You see it, you go. It comes this way. With J.C., it goes that way. Most mainstream media representatives have to worry about getting fired or reprimanded or just having your ass chewed for disturbing the relationship between the government agencies that feed us information for our survival. In other words, sometimes the lion in the zoo is very nice to the zookeeper because the zookeeper brings him a big steak every day.
And what does that mean, be nice to me? I mean, she's not saying be professional, don't be rude. She's actually saying be nice to me. Suck up to me. And then I'll respond.
It's exactly what she said.
I mean, that's not for a government official to say, is it? I'll retaliate against you by not treating you as the media and not providing information to you unless you're nice to me.
Right.
Okay, second one. This is another quote from Jan Caldwell. And there's only one sheriff's department in town, and you can go talk to all the deputies all you want, but there's one public affairs director. Just be nice to me. If you're nice to me, and when I say I'm sorry, I don't know the answer to that, but I'm sorry I can't talk about that, I'm not lying. I'm not lying to you. 32 years with the FBI, 6 years with the Sheriff's Department. I believe I have integrity, because if you don't have integrity, you don't have a good soul. Then you have nothing. That's my soapbox on that. Yeah, because if you're in the FBI and you're in government for 32 years, that is mutually exclusive from ever having lied, correct? That's proof right there.
Earlier in the program, we talked about the world-renowned forensic scientist, Dr. Henry Lee, on a witness stand claiming that a towel had blood on it.
But I think that example, you can give the benefit of the doubt and say that he was just taking the easy road, just thinking it really didn't matter. Yeah, it was blood. What does it matter anyway? Because they did it. They murdered him. You know, what's the big deal here? So, but we have better examples of government officials who have outright lied, Ed. You know, outright.
FBI, right?
Right.
FBI officials.
I mean, up the road in Boston, you know, with all that happened up there with Whitey Bulger, come on. How can you possibly say I was in the FBI, so of course I have integrity and I don't lie? You know what? Maybe you do, but you're like every other human being. You have to show it and prove it. You just don't get it because you have a title.
Well, it's no different than JC.
It's real simple.
If
anybody believes that the government's not lying, they're the dumbest people in the world.
Recently, there was a trial of 2 officers in San Diego County, 2 members of law enforcement, and the media was not. Cameras were not permitted in the courtroom. Am I correct?
Correct.
No cameras.
Because you had a DA that was playing games.
No cameras were allowed in the courtroom. Why?
No cameras.
Why?
Yeah, exactly. Why?
Well, I know up here sometimes they say, well, the officer has been undercover or will be undercover, and it's for security reasons.
No.
Well, you asked me why. I'm just trying to think.
That pertained
He's a government
that
employee.
that pertained to depositions, video depositions.
Okay.
Once the officer has to take the stand in a public courtroom, game changer, rule changer.
Well, maybe not.
Especially when they're sitting at the defense table as defendants.
I think
Game
there's-
changer.
I think there's a lot of defendants that would rather not have the camera on them.
Absolutely.
And most of them probably.
But why?
Defendant that want the camera on him.
But why wouldn't they permit him in the courtroom when two officers are on trial? Well, maybe these guys are going to go back to work, or we don't want other people to see who the. Yeah. Never mind. Go ahead.
Okay.
What else
next.
did she say?
Okay, now we're getting into a whole nother area with regard to and this may be a panel for next year, journalism credentials and who should have them and should we have them. And I'm going to throw that back on you all in a minute to find out what you think. So then she got a little bit into discussing credentials, government credentials. I guess that came up. Is that still a hot topic out there, JC? Are people still discussing it?
Your local media wants that topic to disappear because it creates a special class for them.
Right.
They don't want to lose their
Every time
status.
the topic's brought up, they cry because they're being put with the rest of us Americans.
Next.
They want to be a special class of losers.
Next, because you can sit with your Apple laptop in your fuzzy slippers, you can be 800 pounds, a disabled man who can't get out of bed and be a journalist because you can blog something. And I don't think she said that in a way that meant she's being inclusive. I think that she was speaking with derision pointed at the people that she's talking about. The fact that you can be disabled, the fact that you can be 800 pounds, you can, be in pajamas, to her, that's not right. That's not a real journalist.
Well, I want you to just think.
But not to be 800 pounds in fuzzy slippers.
I just want you to consider something. News Now Houston, 155,000 subscribers. J.C. Playford, 33,000 subscribers and growing. Summary Judgment, 2,000 plus subscribers.
1,800.
We don't have. Joe Cool in Chicago, 4,100 after 2 weeks. I mean, if he printed a newspaper and 4,100 people subscribed to his newspaper, he's a fucking newspaper.
Yeah.
If J.C. Playford published a one-page document like they did back during the Revolutionary years, late 1700s, one single page, okay? But they had 33,000 people paying a penny back then for a piece of paper. That's a paper. That's a news media. Who are you, the government? And this is where the Constitution comes in. And it talks about Congress shall not, but that's been applied to the states by the 14th Amendment. The First Amendment applies to the states. That the state can't, and obviously if the state can't, the local municipalities can't. Who are you to say who is and who isn't? And that is what rubs me. That is what has rubbed me for years, 40 years, 50 years. Who are you to say who is and who is not the media? And as liberal...
Go.
Stop right there. That's very important because this goes to our case. I'm going to explain to you how. If you were to look at the CHP website for what it takes to be a member of the media, that's one of the things that made them get rid of their CHP proof credentials. How the hell are we supposed to determine who's media. That's not our job.
Right.
So they took up the term that if you're media, okay, versus just general public, which is still media, okay, but if you work in the media field, they went, if you've got a business card or how do we say it, a press credential from like American News and Information Services, then we have the right to be there. And that is why they changed that law. That's not law, but that's why they got rid of their credentials.
Their
They got
policy.
through all the CHP stuff because they realized they could not legally determine it themselves. But yet, San Diego PD wants complete control over all those little camera guys. And that's what the press credential's really about. Nothing more, nothing less, but to control the media. Every government person, let's take those raids I was on just a week and a half ago. When we came across the federal government side of those people, their PIO for the day, you know what they wanted from us? To contact them and let us know what they printed about them. Why?
Why would you do that?
But why would the government want? Why would these people, they're asking her, you contact us and you let me know what you said about me.
Yeah, that doesn't make any sense. You know, Ed, I just thought of something while you two were talking on this interchange. And it's something we talked about a lot where everybody's part of the media now. But I don't know if it's that simple. No person is a person is not the media. It's only when the person is acting as the media that they become the media. So even if you're employed as a journalist, you can be at an event and not be the media. You could just be a spectator. You could be a guest, a relative of somebody. And even if you don't work as a journalist, if you're at an event or you're at a scene and you're covering that scene to gather information, then you are the media. So it's all about what you are doing at the time that defines whether you are acting as the media. And I think that's important in this case, in your case, in presenting this letter to the Ninth Circuit, because I think there really is a difference between what Bartlett was engaged in doing and what you have been engaged in doing. You have been attempting to gather news and disseminate information to the public, whereas Bartlett just felt that he had a First Amendment right to scream out his opinion. And to me, the two, and Bartlett may be right, maybe he did have that right, I don't know, the Supreme Court seemed to find mostly not in his favor. But your case is so different from Bartlett's case, and I look forward to the opportunity to show that it's so different.
Night and day.
I mean, JC, it's not a matter of his freedom of speech. It's a matter of his freedom of the press that was denied under the First Amendment.
Okay. The Ninth Circuit was ready to rule on Playford. Lozman came out. They wanted to wait for Lozman. Lozman came out. Lozman validates American News Playford v. Gore. Then they came out and said, let's wait for Nevis v. Bartlett. And if it wasn't for Part D in Nevis v. Bartlett, then they would have overturned Lozman.
Yeah, you're right. Oh my God, what an insight, Ed. That's
They
true.
would have overturned, without Part D in Nevis v. Bartlett, they would have been in conflict with Lozman.
Because you have to have the individual actors violating a right before you could hold the municipality responsible. The municipality can't be responsible for violating a right if some individual didn't do it as well.
And it's not like the San Diego Sheriff's Department did not know who J.C. Playford was, did not have an attitude or have animus towards J.C. Playford. Okay? And you know something? They were going to harass him until he was nice to them.
Right.
They were going to keep beating him up until he was nice to them.
Here's a couple of the things that went on. You ready for this? Prior to my first arrest, I was informed by Deputy Hodge, one of those cops involved in Molly Malone's, that they were going to start arresting me for interfering whenever I showed up because they want to get rid of me. If I keep showing up, I'm going to be arrested. Boom, next thing you know, I'm arrested. As the words would come out of these people's mouths, these things would happen. We had a sergeant from Poway one day when I was sitting there with a friend talk about how, oh, you can't chase us down without a driver's license. We made a move on your driver's license, and that's how we got rid of you. They started attacking my driver's license and me because if you get pulled over so many times, then your license gets suspended no matter what. And they started playing this game. If you look back at the driving record at that history, the San Diego Sheriff's, and there's an email on this, by the way, that the Ramona Sheriff's Lieutenant Frazier sent an email to the San Diego Police Department telling them to fuck with Playford on his driver's license. Go fuck with him. And SDPD sent my picture around their lineups and told them to mess with me. And every time I pulled up, I got stopped, I got harassed, I got pulled over, I got ticketed. It was absolutely disgusting.
So listen to this, and this goes into this, again, another quote from Public Information Officer Jan Caldwell, San Diego County Sheriff's Department. She's talking to the Society of Professional Journalists in February 2013. Quote, does that give you the right, because you blog in your fuzzy slippers out of your bedroom, and you don't go out, and you haven't gotten that degree? Should you be called a journalist? Or should you be like Pauline, who graduated from journalism school and has been doing a long time, or JW or Dennis? I mean, are you on the same par? How does anybody even talk like that, Ed?
You know the best thing about those people right there?
Yeah?
Those are the people that set her up.
I guess she misjudged who was being nice.
What a lot of people don't know is that when the Society of Professional Journalists did that thing with Jan Caldwell, they did it for us. They went, JC and Ed are taking a lot of heat for us. What can we do for them? And this truly is what they told me. And this is how they came up with this whole thing with let's get Jan Caldwell down here and get her talking.
Well, these comments came after our initial complaint. And when you won, well, you had not yet been found not guilty for the May 25th, 2012 event. I believe we amended the complaint after you got the not guilty, and then we found out about this information and we added it because it does help the complaint. Because Jan Caldwell is a policymaker, what she says can be considered the opinion of the agency as a whole, and that's where your liability for the county comes into play.
A lot of times a police supervisor will call up their PIO and say, how do I handle this? What do I do? Now, we don't have any evidence of what Jan Caldwell may have said to do, but when she's out at a scene and they say, Playford's here, and he's out on the side, what do we do? Send them over to the media area. Well, no, I'm not a piece of cattle. I'm not a piece of beef. I'm not a sheep. You know, don't put me in the pen. I'm going to go where I'm entitled to go and stay out of my face.
So finally, this is the last quote we'll have today from Jan Caldwell, but it's been a while since I've read these. And they still surprise me. Quote, in my estimation, and I'd like to hear from Darren and Michael on that, because Pauline and JW and Matt and the others that have been doing this a long time know the questions to ask, as will you. But if you're sitting at home on your laptop, does she have any idea how many graduates of journalism school do sit home on their laptops now and write?
Work out of their house.
I mean, people do that. Sit at home on your laptop and you're blogging and you just want to get under my skin for your city beat. I love that. Then yeah, so I'll drop that out on you. What do you think about that?
Now, let me give you an example of something. Jan Caldwell makes a statement like that about sitting at home on your laptop. To the people on the other side of the camera, I can guarantee you this. There are individuals who were well employed by brick and mortar media outlets, the Hartford Courant, the Hartford Times, the New York Times, the Washington Post, San Francisco, San Diego, and they have been downsized because the print media is having a problem generating revenue. Some of these people have actually gone out to their living room and used the internet to create a website to start to do what they did up there.
Absolutely.
From their laptop in their living room with their fluffy pink slippers on, and they're posting stories. Now, what's the one that's always being quoted in Connecticut? The woman started.
Connecticut News Junkie.
Connecticut News Junkie.
Yep.
Connecticut News Junkie is an online media organization that was started and is currently staffed by former full-time employees who may have been downsized and down-outed from their full-time job. And now it's up to Connecticut News Junkies to solicit advertisers and financial support to support their news media business. There's the Connecticut Mirror.
Yeah.
There's another one too. But the Connecticut News Junkie is very heavy into covering the state legislature. Okay? And these people, a lot of them are working out of a room in their house.
Absolutely. They're not having the overhead. They're not working at some big brick building that's rolling out piles of paper.
But back in 2013 or 2012, when these statements were made by Jan Caldwell, little did she know the direction that the media was going.
Well, she should have known.
Now, I'll give you an example. I started with a video camera in 1986, and by 1988, I had what's called a prosumer camera. It wasn't a professional camera, it wasn't a consumer camera, but it was a smaller, cheaper camera. And the cops used to come up to me because they were used to seeing these big $35,000 cameras for the mainstream media, and they would come up and they'd say, "What the hell's that? What kind of camera is that?" And my statement to the police at the time was, "Do you have penis envy? Do you think that bigger is better? 10 Scotty dogs can beat the Great Dane. 10 little cameras can gather more news than one big camera." And when Mayor Baird in Washington, D.C. was caught by the media doing drugs, they used a little small handheld camera. What was referred to back then and still is the predecessor to the cell phone was the palmcorder. They called it a palmcorder. When the first Gulf War took place and the embedded media representatives were going to ride along with the military forces in the desert, the mainstream media people purchased a bunch of consumer-grade, high-definition cameras, supplied them to their reporters, because if they got sand in them or they got thrown and banged around, they were throwaway cameras to them. You could throw away 85 of them before you pay for the big camera. So I predicted years ago that the cameras would get better and better, and smaller and smaller, and better and better and smaller, and they were going to it was going to become simple to operate. Now here's how simple it has become. I can pick up my phone, I can go to the home screen, I can hit my camera function, I can look through the lens. It's 1080 high definition. I can turn a little floodlight on. I can take video. I can upload clips to the internet, and the news media will pull them down and use them on a regular basis.
With your permission.
With my permission. Because most TV stations, and I can't remember what ABC in Connecticut calls it, it's like you report it. You send in video to them, and there's a disclaimer that you're giving us the right to use your video free of charge. So people submit to the TV station, and their video is on TV, sometimes with their name and their credit. Okay? And I'm just telling you, they got smaller, they got better, they got simpler to operate, and now almost every person walking in this country, 6 years old to 90 years old, has a news media camera in their pocket.
Yep. So, JC, we're going to let you go. Do you have any final words of wisdom?
Yeah. When it came to one of the statements of Jan Caldwell, everybody goes right over it, and that is they know what questions to ask.
She was acting like if you go to journalism school and you're a real journalist that doesn't just sit at home with a laptop, you know what questions to ask, and you don't waste our time asking those pesky questions that make us uncomfortable.
Can you imagine the case in South Carolina where the officer shot the guy running away, and they're at a news conference and the mainstream media goes, and tell me, was there justification for the shooting? And the media representative, the PIO, says, absolutely, he had a firearm. And then a week later, and then somebody's at the news conference saying, is there a possibility he didn't have a gun? Is it a possibility that the firearm was planted on him? Absolutely not. What kind of question is that? You disregard that. And then a week later, the video surfaces that the reporter knew about. See, J.C. Playford knows and hears things before the mainstream media does. So they're at a news conference asking questions based on the information that's been given to them by government. So they ask a question. J.C. Playford knows what was told to him by people at the scene and then asks questions. And they don't like those questions. You know, I was at that news conference in Glastonbury, and I asked the question, you know, is it true that you found the people, the car and the occupants, based on the new system they have in the Hyundai cars, that Hyundai knows where the car is all the time? And the cops just shut it down. They came up and said, how did you know that? They weren't going to say it, and the media wasn't smart enough to ask it, but I happen to know that's how they caught the guys. From a very reliable source.
Yeah, I don't know why I thought of this when you were talking about that, but have you been following the story from this week of the Navy SEAL
Yes.
who was on trial
Yes.
for murder?
Yes.
And then somebody got up there,
Corman,
the medic, right?
the medic.
Got up there, and he had immunity. He'd been granted immunity by the prosecution, and he said, I'm the one that killed him. That's like a movie. That's nuts. And it totally blindsided, from what I've been reading,
The prosecution.
The prosecution.
Yeah, that's in San Diego, by the way.
Is it? So
Yeah, it's playing out here in San Diego.
so it must be getting a lot
Well,
of
let
coverage.
me say something for the record.
Boy, to have a camera in the courtroom for that.
You can.
I know.
There are things that I witnessed or did in combat that I will take to my grave. Won't talk about it. because it was combat, and I was with a bunch of brothers, and I can understand where the corpsman's been. You know, you gave him immunity, and he says, "Okay, you want to know the truth? I did it." You gave him immunity. His immunity, I'm sure, was.
How he did it.
And the immunity, when they give it, is usually has one main condition. You must tell the truth. You cannot lie or withhold. You gotta tell the truth.
But doesn't immunity also have as a condition that you have told me the truth? You've told me everything. You've told me the truth, and now I'm going to give you immunity. Because how can you give somebody immunity if they haven't told you the truth?
What if they never asked him?
Well, I got a question.
Yeah,
Do you think the prosecutor ever asked the corpsman, "Hey, did you kill him?"
that's the issue.
That's the issue.
That is the
I
issue.
wasn't asked, so I didn't answer. But the defense asked, and I answered.
Right.
Yeah, that old thing. Well, he never asked me.
Yeah.
Isn't that what people say? He never asked
I
me.
have not lied to you, and I withheld nothing. You asked, and I told you everything I knew based on your questions.
But wouldn't the prosecutor have asked him? Did he kill him?
Listen,
'Cause what are you
can
gonna
you
have
imagine somebody coming up to me and saying, "How many people have you killed in your lifetime?"
Well, I don't think you should answer that.
No. But you go like this.
Don't answer that.
I don't know. Now, if you ask me in the month of January, I could probably tell you. January 1968, I could probably tell you. But if you ask me the end of August, beginning of September, what happened in a different location, oh my God, I don't know. But what an open question to say to a person who's in combat and goes out on missions all the time. Did you kill anybody? Buddy, I'm a fucking SEAL. I'm a medic with a SEAL team. What do you think I did? That's what I got paid for. So you don't bother to ask him the question, because you anticipate that he would never do something like that.
Right.
And then the defense, who knows their client didn't do it, and the defendant probably knows who did do it.
Right, he's got the story.
And, there's a discussion between the defendant and his lawyer saying, look, the corpsman's got immunity. He can admit it. And they can't charge him.
What you're saying makes sense, because as a defense attorney, what you often run into is your client will give you information and say, this is why I'm not responsible, this is why I didn't do it, this is what mitigates what I did, whatever it is. And I want you to convey that to the prosecutor, because I'm looking for a better deal, or I'm looking for the case to get dropped, or whatever. And so you go convey this to the prosecutor. You may even have a video. You may even have audio. You may have text messages. And the prosecutor says to you, I don't want to see that. I'm not listening to you. I know he did it. They blind themselves to anything that's not consistent with what they believe the narrative is. So to me, as odd as it may seem that prosecutor didn't ask the right question, they never ask the right questions. They don't want to know the right answers. They just want to go down that path that they believe is true, that's been dictated to them by the police officer, that they're going to defend to the very last.
Let me ask you a question.
I cannot believe it when you try to show a prosecutor audio or text or emails that they don't want to see it.
We started at 8 minutes after the hour, so at 53 we'll have an hour and 45 minutes. I'm going to want to stop, but I want to just say this, okay? I truly believe that Jim Chapin, the attorney representing the county of San Diego,
He's retired now, been replaced.
but he truly believes that these deputies did nothing to instigate and to antagonize J.C. Playford or provoke him into doing
Right.
what happened.
Right.
He truly believes, oh, they wouldn't do that.
Right.
You know, do you think that Jim Chapin went down and said, why did you tell Deputy or GHP Nielsen that his media credentials weren't valid, he was fake, and he's not the media?
You know,
why did you say that to him?
It's a good point, Ed, because, we're talking about war. You want to dehumanize the enemy. You don't want to know that they have a family. You don't want to know anything. You don't want to know they're human. You don't want to know anything about them because it holds up your mission once you start doing that. And I think the government mindset, even though the people should not be the government's enemy, I think they developed that too. It's like they don't want to know JC's situation. They don't want to know what he's been through. They don't want to know both sides of it because then it's not black and white and then it's too freaking difficult to deal with. It's so much easier to see the world in black and white, good and bad, with no nuance. And government tends to do that.
And with that, I'd like to wrap up. And like I said, I may not be here next Saturday.
Well, on the show.
On the show.
Okay.
I'm going to be around. I'm just
Okay.
not going to be here.
Okay, good.
When the smoke clears, Ed, first of all, we love you, bro, and you do real well with this hospital shit. You know, when the smoke clears, they're going to find out how the attacks on me were personally orchestrated as attacks.
I think we're going to survive Nevis v. Bartlett. I think that the evidence that Rachel has presented in the complaint is overwhelming.
Well, the complaint is not evidence. The complaint is allegations.
Okay.
So have we stated a claim in the complaint?
The facts.
As a legal matter, and the facts that we've submitted, are they enough to survive summary judgment? That's going to be what it comes down
Right.
to.
And I got to tell you,
And you know, and here's the funny part. We're talking about the Ninth Circuit. You know why the Ninth Circuit's scared to rule on me? It's because they know the Supreme Court keeps fucking going against everything the Ninth Circuit says.
Yep.
And here they're trying to do what they normally do in the Ninth Circuit, destroy our constitutional rights.
I don't agree with that at all in this case. I do not agree at all. I think we have a court that is on the forefront of respecting the First Amendment. Maybe not other rights, but the First Amendment.
well, I got to tell
yes.
you, there's some Supreme Court decisions that have come out lately that have totally shocked me because they just did the one over the Mississippi judge and the trial of the black guy that's been tried 6 times, giving him a 7th trial, and they went after the judge for trying to come up with an all-white jury. And I believe it was unanimous.
No, not Clarence Thomas.
They went after the DA for it.
Right, the DA. Yeah.
All right, listen, JC, we got to go.
Okay, everybody have a great week.
Talk to you, brother.
And we will try to be here next week with the show.
Okay. All right, now, is this...